Hello, hello. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We have 5 people in the chat, but only 2 likes. Give me the likes. Helps with the algorithm. All right, let's get answering questions. Let's first introduce our co-star, the classic Suntory whiskey today from Japan. YouTube user Pamaroon says, question, is it good practice for a plaintiff's attorney to take a settlement data sheet from the defendant's attorney and share it with you before a settlement proceedings to say this is the history of settlements? Let me read that again, make sure I understand. Is it good practice for a plaintiff's attorney to take a settlement data sheet from the defendant's attorney and share it with you before settlement proceedings to say this is the history of settlements? Well, yes and no. Every case is different. So what happened in other cases has nothing to do with what should or could or will ultimately happen in your case. That being said, extrapolating from data is comforting and can, in certain situations, be useful. Now, it sounds to me like plaintiff's attorney was trying to reality check their client, right? I don't know if it was a data sheet compiled by the agency you're presiding in. Excuse me, frog in my throat. I don't know if it's a settlement sheet composed by defense counsel. If it's created by defense counsel, instantly I have doubts. I'm not saying defense counsel lie about everything, but I am saying if defense counsel is saying something that's not under oath or verifiable in some way, nah, not a thing, right? Now, if I'm just going to assume that this data sheet is like, these are the settlements in this agency that your case is pending in, as compiled by the agency, a neutral third-party body with some credibility. And notice I say some. These agencies are not all above question, right? No, I've not coughed all day. Get on live and I'm coughing like crazy. Maybe it's the whiskey. So, listen, I think it's probably a reality check. I think there's a reason why that attorney came to you with that data, but you know, it's very situational. If that would be good or not. Sean S says, good afternoon and have a happy and safe holiday, everyone. And Sean S, a happy and safe holiday to you as well. Excuse me. Tez Zinro, hello. Kim says, does fraudulent inducement of employment, misrepresentation about being a managerial job, support claiming constructive discharge? Thank you. It might. So, are you arguing constructive discharge to receive unemployment benefits? That's going to differ from jurisdiction to jurisdiction in terms of whether or not they're going to give you unemployment benefits because there was a bait and switch on that job offer. YouTube user My Other Channel says, good afternoon, Vincent. How long does it usually take the EEOC to record a complaint, Form 5, and provide the plaintiff and their attorney with that acknowledgement? Less than 2 weeks, in my experience, when you have an attorney involved. Gabriel's Tears says, my case investigation was transferred to the district office. Is this normal? What does this mean? Could this indicate a class action? It's very normal for cases to be transferred around. I would not be concerned about that. So sorry. I would not be concerned about that. No, I do not think it is indicative of a class action. Unless you have been contacted by a law firm who is currently running or putting together a class action, you will not be involved in the class action. Generally speaking. Listen, could it happen? Sure. Will it happen? It won't. Bubblegum, happy Friday to you as well. Tez Inro says, do you value cases differently depending on if they're with the EEOC or FIPA? Does it depend on the FIPA and their history? Well, cases are valued. I mean, the general answer here is that cases are valued differently based on their jurisdiction. So an EEOC case that's in California, but is pending through the EEOC and will ultimately go to federal court in California, is generally speaking going to be worth more than an EEOC case that's pending in Louisiana, depending on the protected classes and everything else. Matthew, if you're trying to negotiate a payment plan on a live stream with our firm, I suspect, well, I don't want to be rude, but Matthew, I would not, if you're dealing with intake of our firm, I would not recommend engaging in trying to negotiate that offer on a live stream. Would be my personal recommendation to you. I'm sorry, I don't mean to be rude, but that I'm not the kind of person who's going to be embarrassed, but I am the kind of person who might be petty. So just heads up. Pat 1985 says, if a supervisor is caught lying in a response to an interrogatory and he stated no document existed, when a dozen incriminating emails were later located, how likely is the defense to offer to settle? Oh. Okay, let me read that again. If a supervisor is caught lying in response to an interrogatory, so a supervisor lied in an interrogatory, and then he stated no documents existed, when a dozen incriminating emails were later located, how likely is the defense to offer to settle? So Pat 1985, the question is, how important is that witness? If that is a linchpin witness for the defense, whose credibility has just been seriously undermined, it does slightly increase the chance that they might want to settle with you. If it's not an important witness, it may not meaningfully move the needle on how likely your case is to settle. Poll Girl 2011. Do you have a disability retaliation case if the manager put in an email that they are not training you for the new role you're in because you miss 4 hours a week due to your 88 modified schedule? Yes, that is certainly a claim. Hey, Ray, how you doing? NYC damages. I know this is not your expertise or practice, so I'm going to right off the bat, I don't answer questions outside of my expertise because I'm not good at it. So why would I give you answers? But let's read the question. But if after employment discrimination, social services also discriminates against my family, including kids, can you refer to an attorney in New York City to file a discrimination case against the city? Oh, okay. You might need what's called a civil rights attorney, which is the hippie version of an employment attorney, right? Employment attorneys are the like grumpy accountant versions of like human rights law, like is the best way to put it. And like civil rights attorneys are like kumbaya, prayer circle, drum solo on the bongos, like, but also you can't beat that man that way, Mr. Officer. And they can be great. The problem with civil rights attorneys is that they're civil rights attorneys. Some of them can be amazing. So this is clear. There are amazing civil rights attorneys. Listen, the entire civil rights movement was the spine of that movement. The foundational support was like amazing civil rights attorneys, and they were amazing. But often when I like talk to a civil rights attorney now, he's like, got a giant ponytail. Nothing wrong with a ponytail. Got a giant ponytail. And he calls me man. And it's just like, okay, I guess you win cases. Like, doesn't feel like you win cases. But as long as he wins cases, it's good enough for me, right? I just check their credentials, right? There's a lot of attorneys who are like, I went to law school and I'm a civil rights attorney. Cool. How many cases? How many trials? What have we done? Show me your press page. Like very much check that person, right? Hello, Luann. Po Girl 2011. Can they remove your modified schedule and make you get FMLA instead? That's situational. If your modified schedule is no longer reasonable, then it is possible. However, that would be a big change, and I'd have to know why. why your previously granted accommodation is no longer reasonable. Mr. D says, so I'm still dealing with my settlement agreement. I'm sorry, buddy. That sucks. The defense attorney is now trying to amend the agreement to add language in it to prevent me from working with an independent contractor. See there, I think they're getting a little abusive with you, because now it's not pending in the agency. So everybody, really quick, history on Mr. D. Mr. D's got a settlement agreement that he achieved for himself pro se, and I believe, correct me if I'm wrong, Mr. D. And as part of the agreement, they had a term sheet, but no settlement agreement in place. Mr. D was pushed to withdraw a case from, I believe, a state agency where it was pending. And once he withdrew, the settlement agreement process slowed to a crawl, and defense counsel started throwing in additional provisions and demands that were not in the term sheet. Mr. D goes on to say, the original one they sent me did not include it. So I asked about it, and they were like, oh, yeah, we meant that too. Mr. D, it's legal if you sign it. If you don't sign it, then you have to go through the work of reopening the case. Juana Washington says, I complained about sexual harassment based on gender. They met with me in person. They said they would investigate. Same day, given an unsatisfactory performance evaluation. Is this retaliation? Sure sounds like retaliation to me. Certainly, it sounds like you have both a sexual harassment claim and a retaliation claim. Kim says, why employment lawyers don't seem interested in doing civil RICO when checking all the boxes for such claim? Is it only pursued by civil rights firms? Civil RICO is an incredibly complex thing to litigate with a very high standard. So civil RICO is not like criminal law RICO. Criminal law RICO is essentially the government says they don't like you. They said some shit. Now you're going to jail. It's that simple. Like, it's just like when the government uses RICO in a criminal context, all it really means is we've decided you don't deserve civil rights. You're going to jail, and nobody's going to help you because people don't like you. We all pretty much think you did a bad thing. When you bring civil RICO claims, right off the bat, judge is going to be like, that's a pretty high bar. Counsel, you think you can prove civil RICO? That's a complex thing to prove. So, yeah, where is Ken White? Exactly. No relation. I have no relation to Ken White. So when you bring civil RICO, it's not like when you bring criminal RICO. Long story short. WT71 says, Vince, thank you for the live stream. My pleasure. I hope it helps. My question involves my lawyers who are trying to get my case certified as a class action lawsuit involving ADA disability discrimination. That's amazing. Congratulations. For years, my former employer always accommodated my disability. For years, my former employer always accommodated my disability through use of FMLA as required by my former employer. That accommodation ceased, and I was told I no longer qualified for FMLA, and I was terminated after 24 years of service. Can you explain class action lawsuits and how they work involving employment law? Okay, so I have a couple of videos about class actions that are going to do a better job here, but I will try to give you a quick rundown. Real quick. Oh, there's more. Also, how long does it take to get a class action lawsuit certified? The case is in the 5th Circuit, specifically Texas. Thank you. Okay. So how long will it take to get the case certified? Longer than it would take for you to run through your entire case as a solo client. Let me get this out of the way real quick. I have a bias against class action litigation, and I've worked on class actions. I've worked with firms doing class actions. Our firm has been involved in class action work, and I think very well of some class action firms. Great experiences with Fittipelli and Schaefer out of New York. Really think they're swell. That being said, I have a bias against class action work because, first and foremost, generally speaking, class actions are how attorneys get wealthy. But it does seem to me that the members of a class in a class action rarely do anywhere near as well. Now, class action work, when you're involved in it, gets kind of ugly. There's a lot of things that happen, like firms will get staffed up, right? They'll get a certain number of class action clients, and different firms are going to gather different groups of classes, and they all have to collaborate. And a lot of the firms that have a good chunk of the class members will then hire tons of attorneys to bill tons of hours on the case, because they know their attorney fee provision in any settlement will probably be much larger than what they would get from the contingent percentage on a class action. So you'll see firms, I've worked at firms where people like rent out an extra floor of a building and fill it with attorneys just to work on a given class action. And those attorneys just answer calls from class members and say things like, yeah, not yet, no money yet, we'll keep you informed. And then they bill lots of time for it, right? I'm not saying they bill too much time for it, but I'm saying I wouldn't bill that way. Now, essentially, class actions are powerful because they multiply the risk to the employer in the realm of class action. That's what you're doing, right? Your case has a certain amount of risk. A class action with 300 members, all of whom have similar claims, has 300x the risk, 300 times the risk, right? That means the employer basically needs to settle, because even if they think they're going to win, God help them if they don't. The business is going to be gone, right? Now, that's great because you're going to get a settlement. It's not great because you don't get very much say in what settlement you get. You get what the attorneys arrange for you. You can challenge it, you can opt out, but it's hard to do that. And doing that means you're kind of going back to square one. And you guys bring your case by yourself again. Only now, there's not a bunch of other risk helping your case move along anymore, right? So class actions can be cool. They can be powerful forces for change. They can help large groups of people. But I get frustrated with them because they don't put money in the hands of clients in the way I feel that they should. And that sucks. But definitely check out those videos and just know that, like, listen, I definitely know good class action attorneys who definitely help people. I've already named one firm that I definitely feel that way about. I also know firms that had fee fixing scandals where they had class members and maybe they reached a deal where they would take a certain amount of money up front to settle all the cases that came in their class later on at a set fee. That sounds unethical to you. It sounds unethical to me, right? Like, it just isn't right. And in those situations, the plaintiff's firm might get in trouble because plaintiff's firms are required to be ethical, but defense firms are not. Defense firms are generally too large to be subject to things like ethical rules, and nobody ever holds them accountable, generally speaking. So, like, the defense firm doesn't even care that happened. They're like, yep, let's go back to fee fixing. Sorry about that. Sorry about what happened to you with the sanctions. Not me. Trust me, not me. But watching it go down is wild. Watching rules apply to only plaintiffs firms and not defense firms is the story of the legal industry. But it's very annoying. All right, going back. I think I missed a question from YouTube user Bubblegum. Oh, and go check out all my videos about class actions. I got a bunch of videos on the channel about them. I hope they're helpful. YouTube user Bubblegum says, my case is under investigation with HRC. I have an attorney. He wants the summary. Does he want your summary of events or summary judgment? What kind of summary does he want? Oh, he wants the summary from the investigator before we ask for the right to sue. Will the investigator provide a conclusion to the summary? I don't know. I don't know if they will or not. If I knew, I would answer you, but I don't know. I'm sorry. Excuse me. Poe Girl 2011 says, is it also retaliation when your emails asking why the accommodation is being removed are ignored for months at a time with follow-up every 15 days? Yes. I mean, I would view that more as a failure to accommodate, but I think it's also retaliation. What else can be done if they're refusing? You can file your case. If they're not going to live up to their duties under the law, you're going to have to file. Ooh, my chat jumped ahead. Mr. D says, you are spot on with your recount of the case. Excellent memory. But yeah, I know this is turning into a poop show. but is what the attorney doing ethical? Needs some leverage. He seems super dependent upon his higher ups and gets nervous when I press him on stuff, turning into a poop show. But is what the attorney doing ethical? Needs some leverage. He seems super dependent upon his higher ups and gets nervous when I press him on stuff. I mean, Mr. D, I don't think he's negotiating in good faith, but his ethical duties are to his client. And is it an ethical breach for him to, I mean, I feel like he tricked you a little bit. Not, you didn't do anything foolish, but like he's got a slight upper hand now because the case is not pending anywhere. And it's a big hurdle for you to get it back on the docket somewhere. So, you know, he's going to use the advantage. And I don't know if it is unethical. I mean, I guess it depends on the ethical rules wherever you are. In New York, I think they would call that sharp practice and probably be like, it's defense attorney, so that's okay. Ray Bethel says, how important is the lack of pre-adverse action and adverse action letters when a company jumps the gun and fires you due to a background check company making a mistake and then lies? How important is the lack of pre-adverse action and adverse action letters? I mean, your adverse action is the termination. I'm not sure I understand, Ray. Oh, you're saying they lied. There's a pretext in why they terminated you. Temporal proximity is going to be everything for you if they have a pretext, right? If they did the background check and they fire you immediately after that, that's going to be very compelling, especially if the thing they're complaining about in their pretextual letters were unrelated or not close in time to the events that happened. Lois Osmond says, employer doesn't realize I'm still on their email list. They recently sent an email now enforcing the policies they were violating while I was employed. I believe this probably has something to do with my current lawsuit against them. Could this be another evidence or even more of a smoking gun for my lackadaisical attorney? It could be. I don't know. I don't think it's a smoking gun. Could be a data point. Could be a piece of evidence, certainly. YouTube user Meow Meow says, I had a contingency attorney. He had some consultations with me and later said he cannot represent me after checking my documentation. He has not done anything and yet accept consultations. Do I have a lien? No, if you didn't sign a retainer, you wouldn't have a lien. Sounds like you didn't sign a retainer agreement. Generally, to have a lien in any jurisdiction I'm really aware of, always check local counsel, but generally you need to have a retainer agreement in place. Verbal agreements for legal representation over $1,000 are going to go nowhere fast in most parts of the country. Even, listen, if I caught an associate doing a verbal retainer for like $800, that associate would have a lot of explaining to do. Get it in writing, always. My other channel says, following up with your recent video about not filing a rebuttal statement, what is the main deciding factor in deciding to not file a rebuttal? Does having a strong retaliation claim play a role? Your desired path. Your desired path forward is your main deciding factor. If you want a settlement, there's a really good chance that you should be doing a rebuttal. If you don't want a settlement, at least you don't want a settlement at this time. You want to go on to federal court. You want to litigate the case. You might want trial on the case. Then there's not much reason to do a rebuttal at that point. Trey Moore says, can you file a complaint with the ARDC if an opposing attorney lies to defame your character in an EEOC position statement? Let's see. I mean, if you can prove the attorney knew she or he was lying, maybe. I mean, that if they knew they were submitting false statements, which is a high bar, like how are they going to know? They're relying on what the employer tells them. But if they knew, I mean, I guess that's an ethical violation. You could certainly pursue ethical arguments against that attorney. Okay. C note 1906. Got that C note. What does your employer do internally after being served? Do they try and get their story straight? Do they dive into communications like Slack to find weaknesses? Do they take it seriously? Thanks. Most employers are going to hire defense counsel, and defense counsel is going to do immediate things like start investigating, demand documentation, grab the Slack, grab the IM, grab the text, the internal text or whatever it is, the emails. They're going to also have trainings about not retaliating. First step is triage, make sure the case doesn't get worse. Second step is figure out how bad the case is. Third step is decide if they want to pay you money now or if they want to go to trial and try to fight it. Juana Washington says, the EEOC is interviewing me on August the 12th. I've been looking for a lawyer already because I only have 90 days to file. Is this a good idea? Excuse me. Yes, you absolutely do want to have your attorney lined up before you receive your right to sue letter if you can. My goodness. Sean S says, hi, Vince. Why do some lawyers say call me when you're fired? I think staying and fighting for your rights legally lets you pay the attorney. I choose to fight. Your thoughts, please. That is, so you are describing my playbook. I actually have videos on this even recently, but many, many videos. I hate the advice that you should wait until you're terminated to bring a case. I do not think that waiting for termination is the best way to maximize the value of your case. It is a way to increase the value of your case, but I don't believe it is the best way to maximize the value of your case. YouTube user Devin says, not really a question, but a statement. I feel that you can agree with or disagree with. Why does it feel the EEOC, the legal bar, set our work in the betterment of the employer? Like a lot of attorneys deny cases, leaving the employee stuck on how to move forward after receiving the right to sue letter. So, Devin, that is a fair and accurate criticism of our industry. There's a couple things going on. First and foremost, most innocent reason is there are not enough employment attorneys. I will tell you right now that my firm takes at max 450 cases a year. And that might sound like a lot, but I have it almost, I mean, I don't think I'm being silly when I say I have a near infinite pipeline of cases that I could bring, right? So I'm forced to turn away infinity minus 450. That feels bad because many of those people have good, solid employment cases that are worth money, but I can't help them because I can only hire attorneys and maintain quality control on a set number of attorneys. And doing that is a full-time job. Like hiring, finding qualified talent, and making sure they're operating the way you want at the level you want, helping people the way you want them to help people is difficult. And it's more difficult. I mean, frankly, it's more difficult because defense counsel is always going to pay guaranteed 3x what we pay, right? Like if you're hiring a plaintiff side associate, you give them a base. And listen, my base when I started as an employment attorney was $32K. It actually wasn't. It was lower than that. And I argued my way up to $32K as a base. And then you get a piece of the cases you win. Our firm generally has a much higher base than that. And listen, I don't think we've had a first-year associate make less than six figures ever. For a first year who lasted the whole first year, right? There's obviously people who come in, you're like, oh, nope, you're not doing this right. This is not, you're not learning. You're not working. No, this is not going to work. But if somebody lasts the full year, they're always going to make six figures in their first year, historically speaking. Here's the issue. We train up an attorney. Let's say that attorney is in a protected class, woman, a minority, whatever it is. Defense firms are like, woo, that person would look great sitting by the bad actor. That's an attractive young woman. That's a handsome black man. And if I could get them to sit next to this fucking racist, or if I get them to sit next to this piece of shit who wants to grab women all over the place in the workplace, it's gonna legitimize my clients. So based on the fact that I bill my clients probably about $1,600 an hour, whatever a given firm does. Jackson Lewis is going to be lower. Other firms might be a little higher. I can afford to offer my associates things like starting salaries of $265K. And very rapidly, they're going to get up to 300, 400, and eventually $500,000 a year. And that's guaranteed. They don't have to win to get that money, right? You can certainly do that and more on the plaintiff side. The sky's the limit. You're limited essentially by the people you help and how much you help them, right? And that's beautiful. And I certainly know a lot of people who really value that lifestyle where it's like, yeah, I'm unlimited. If I do better, if I help more people, if I do bigger cases, I earn more. However, there's a lot more people who are very, very talented attorneys who say, I like guarantees. I like to know I'm going to make $500K. I like to not work for 9 months and cry at night and lose sleep and then lose a case and make $0 on it while my firm loses $80,000 to $150,000 on it. Right? So there's not anywhere near enough attorneys. So this is a rant, Devin. I'm sorry. I'm giving you the. So we lose a lot of attorneys that we train who become really talented deposition and trial attorneys because they get a lot of repetitions on the plaintiff side. They will then jump defense side. And I don't blame them. I get it. You got a life, you got a family, you got to keep a roof over their head. I get it. You need the guaranteed money sometimes. It's not the way I choose to live, but I get it. Also, Devin, listen, there's a lot of really bad cases out there too. Like there's a lot of people who won't listen to plaintiffs because a lot of potential clients are incredibly abusive towards attorneys when they call them. There's a lot of attorneys who don't have the layers of intake that I have, right? Like, and that there's a lot of people who are like attorneys who are working cases and they don't have the time to work to sit on the phone and listen to potential clients. So they just look for set things and they'll just turn down any case that's not those set things because they have a picture in their mind of what's going to make them money. And they know if they let the person talk too long, there's a possibility that person's just going to start screaming at them and threatening their life and all these things, right? So they just listen and they try to get just the case they're looking for and get you off the phone if that's not exactly what you have. And it's disheartening. But Devin, you have a point. Our industry has to do better. I do come back to the idea that we, in order to do better, need more employment attorneys. Like we need more. And my little training program and the people we bring in, it's not going to turn the tide. I'll tell you right now. Like we would need, if we could pump out 5,000 new employment attorneys a year on the plaintiff side, we'll have the problem fixed in less than a decade. It's not going to happen. It's not going to happen. I don't know how to fix that. I don't have the power to fix that. But it is a real problem. Rebel Smith says, can your employer force you to work with a supervisor who sexually harassed you? And I brought it to HR. HR doesn't want to terminate him, or maybe they want us to work it out. So they can try. One thing you can do is if you feel physically unsafe, you get an order of protection. I think you can also bring your claim, right? Like if they don't want to address your concerns, and they can try to make you work together, but if they don't want to address your concerns, bring your case. Bring your case. Life's a Beach says, I am pro se in a wrongful termination lawsuit. The defendant wants to subpoena my medical records. I told them no. Are my medical records relevant in a wrongful termination lawsuit? Yeah, Life's a Beach. If you are seeking any form of emotional damages, your medical records are at issue. They're absolutely relevant and they will be turned over. Sorry. Anish, can you win a settlement at a hearing? Anish, I made you a long form video answering this question. If you're going to ask a question, watch the videos. I answered the questions in the videos, Anish. It was in the last 3 days, I believe. Oh. What do we got? Sorry, I'm trying to find my chat jumped ahead really far because I talked too long. James Leif Anderson says ADA discrimination EEOC complaint to the EEOC. The employer responds with one paragraph. I hire a lawyer who says he will get the right to sue letter. New charge. An employer doesn't even respond. EEOC will not release the case and continues investigation. Lawyer adds charge. An employer won't even respond. What happens next? You're just going to have to get the right to sue letter. You're going to have to go into court. YouTube user Jose says, Friday afternoon chat. Can anyone say inconvenient? Sorry, Jose. Sorry, buddy. I'm happy. Listen, my busiest days are Monday, Tuesday, Wednesday, and then my week slowly tails off. If there is a better time, Jose, I am open to talking about it. I'm not going to let it bleed in my personal life, but we can certainly talk. John Paul Jones says, wanna get an attorney now. Vincent's critic, pro se plaintiff. Is he my critic? He's not that bad. He's not so bad. Well, say you can get it alone, but you should get an attorney ASAP. I got a right to sue letter and couldn't get an attorney fast in time. Yes, you definitely want to get an attorney as soon as you can. Anish, question. Can you get fired for bringing a workers' comp claim? Well, that would certainly, if you are being terminated for filing workers' compensation, that is a workers' comp retaliation claim, certainly in New York State, and I would think in any other jurisdiction, but check with your local laws. Workers' comp is governed by the state laws of your jurisdiction. Oh, well, thank you. That's very kind of you, Juana. I don't know if I'm a true patriot. I mean, I'm a dual citizen, so some might consider me a traitor. I am a Canadian American citizen. Thank you for the salute, Tezinro. I don't know how to salute correctly. I was never in the military. The Air Force JAG rescinded my... Well, they never made me an offer. Technically. Nina, 2003. Once the right to sue letter has been issued, can you sue the company and manager as an individual? Yes, Nina, you can look at the 1980 claims for the individual liability under the federal laws. You may also have some individual liability under state laws, depending on the state you're in. Check with local counsel. But yes, in certain situations, you can often bring individual liability. James Leif Anderson says, what happens if you have a good case and hire a lawyer saying he will get a right to sue letter, but the EEOC wants it and the employer won't respond to the amended charge? What's next? Got to get the right to sue letter, Leif. You got to go on and litigate. If the EEOC is going to keep the case in-house and litigate it with the DOJ, your attorney will still have plenty of work to do. Don't regret hiring the attorney. LC, I have a case winding its way through the EEOC process. Recently, the DOJ has announced they are investigating for past issues. Is there a benefit to contacting the DOJ? Yes. Yeah, I mean, there's certainly a benefit. There might be some ability to share information. They might include you in their case. Just be aware there's also a risk if they include you in your case, include your case in their situation. Everything's going to slow down to a crawl. The DOJ, they're not bad attorneys, excuse me, but they are government attorneys. So they don't have to win to keep their job. A plaintiff side attorney has to win to eat, right? I mean, that is what it is. There's no plaintiff side attorneys running around with a losing record getting paid. They're already in the ground, or doing PI or something else, right? They ran away working for Geico. Devin, you're welcome. I wish I had more positive answers for you, but what you're describing is a point of frustration for myself as well. Something I try to do, like I try to get young attorneys to go into employment law, but I won't lie to them. Like the quality of life in employment law is poor. It is the single best way to turn time, attention, and aggression into dollar signs that I've ever seen. But the quality of life is bad. So if you're like me and you're a trailer park kid who just wants to not live in a trailer, just wants some money and is like, hey, I can help people make money. This sounds great. And like doesn't care about the quality of life, it's fantastic. It's the dream. But I will say, it's not for everyone. Juan of Washington. Since my sexual harassment complaint, they still make me work closely with this manager bad actor. This has increased my claim. I would say it does. I think it certainly increases your emotional damages, and I think it might increase more than that. LC says, my goal has always been to create change at my work. My case is retaliation and discrimination. I think that is admirable. I always push back when people say that the plaintiffs in this field are just looking for money. More often than not, they are looking for either change or to keep this from happening to someone else. Nina 2003, we do have videos in systemic discrimination. I believe you can hit the channel on its web page version. If you go to the channel page, there is a search the channel function in the middle right of the page. And I would search the word systemic. I think we have videos. If we do not, please propose questions and I will make you videos answering them, because that would be a tremendous oversight on my part. NYC Damages says, if you hear someone who is supposed to be the impartial, fair judge in your case talk bad about you to the defense team, is this ex parte communications, and what do you do about it? Thanks. Well, I mean, it really depends on how they spoke. I mean, it wasn't ex parte if you heard it, like you were present, presumably, unless you overheard it through some other means. So certainly I think it's improper that a judge or arbitrator or whoever it is deciding your case, administrative law judge, would be shit talking you. But it might not be ex parte technically. What would you do about it? I mean, it depends on how bad it is, right? Like, I've been in courts in small towns where, the judge is saying things like, Dave, we're buddies. Don't make me find against you. Go settle this case. And I'm like, Judge, what? We're doing a trial here. It's like, Dave, slow down. Dave, go talk. Don't make me find against you, Dave. We gotta play racquetball together. Like, Jesus Christ, Judge. Like, but it comes down to, like, can you get your client what your client wants, right? And if you can get your client what your client wants, sometimes it's better not to crack heads, especially in a small town where if you start cracking heads, maybe you don't make it out, right? I mean, it's always a consideration. James Leif Anderson, file the EEOC case. That's big. Employer who ignores it hires a lawyer, says he will get a right to. I think James, you're just posting the same question over and over again. All right, what do we got? You're welcome, Rebel Smith. YouTube user WT71 says, Vince, is it common to ask for a reinstatement to my old position? It's common. Many people want that. It is difficult to manage. My attorneys are telling me that most employers won't want you back after suing your employer. Your attorneys are correct. So here's why. Even if you were the most amazing employee and you made your employer tons of money, they still don't want you back, because if you go back, any idiot that works for them who does something nasty to you hands you a fresh retaliation claim. And that is terrifying for them, because retaliation claims can be like lottery tickets, and they don't want that, so they don't want you back. I'm not saying it can't happen. I'm just saying it's difficult to do. Team Tahoe says, thoughts on plaintiff me refusing HIPAA and blanket protective orders because I have nothing to hide. I get why you feel that's meaningful, but that's not meaningful. Poor Girl 2011 says, what can a client do to be of help to an attorney when it comes? What can a client do to be of help to an attorney when it comes to their evidence? All my evidence is in emails. Provide it all. Provide it in a word searchable format. If you can, highlight what you feel is the most important. Give an index. These are all tremendously valuable things. We have a big ability to staff up for document review, but a lot of firms do not have that. So, especially if you have a small firm representing you, whatever you can do to lighten the load of document review and discovery review is important. Devin says, woo, It's a bad idea to disrespect an attorney over them not accepting your case. I assume a lot of attorneys are friends, including those from different firms, and the former may warn the current. I think some attorneys will also call the former firm to see why they stopped representing you. Devin, I can assure you that you are correct. I will also assure you that no one will admit to doing that. I do not call people when I see they're getting fired, but I do. So when a firm is getting fired, when I see like a client's like, I'm firing this firm, but I want to hire you, I don't call that firm because I think it would be unethical for that firm to give me an answer. However, I do judge that client based on what I know of the pedigree of that firm, right? So, trying to think of an example here. A while back, a client called me up and was like, I'm firing such and such firm. And that firm was like top 4 most famous employment firm in the country. Okay. Well, listen, things happen. What happened between you? They didn't work the case. They didn't listen to me. They're liars. They tried to force me to take shit money on my case. And they're liars, and they just never did anything, and they're not going to get paid. Unlikely. Right? Because they're not doing anything on the case. First off, they wouldn't be one of the top 4 employment firms in the country. But more importantly, they would be starving to death. Like how would they earn money? Like they wouldn't have the multi-million-dollar firm that they have, right? They have to help people. So the idea that they're trying to get this person to take a bad settlement, quote unquote, a small settlement because they don't want to work the case doesn't make sense. It's possible, but I'll confess to being skeptical, right? So Devin, you're absolutely correct. People definitely question other firms, but people also just make assumptions when they don't want to engage in that somewhat ethical gray area. John Paul Jones says, Vince, what if they lay you off after filing workers' comp claim? How do you prove workers' comp retaliation? Well, I mean, every case is different. You're going to have to take all the evidence that shows that they laid you off because of the workers' comp retaliation case, including things like temporal proximity, and make that argument. They're going to have arguments against that, and you're going to have to overcome those arguments. I know it's not a satisfying answer, but if you ask me how to prove a case that I don't know anything about, the answer is always going to be use evidence. Then when they use evidence, use more evidence and use it better, right? Like that's the only answer. James Leif Anderson, you're more than welcome. Let's see. We got a YouTube user, Live, Love, Die. Live, Love, Die says, denied promotion case, discrimination and retaliation, sex and pregnancy. They came back and said the reason for the denial was due to DOC memo absence. I would, if you're in the OC, amend to add retaliation. Speak to your investigator, see if you can add retaliation to the claim that you have open so you don't have to start all over again. That will time up your right to sue letters so you can get everything filed in federal court together, and then file a single rebuttal against the defendant's amended position statement, which I'm sure they'll amend once you file an amended complaint. Mr. D, I hear what you're saying, and what the defense attorney is doing is pretty shady. What if I just sign the original settlement agreement and say this is what we agreed upon, period, legal? I mean, you could do that. You can tell them you're only going to execute the original agreement, and they can agree or not agree. If they don't agree, you're going to have to reopen the case. YouTube user Anish says, Vince, what kind of hair gel do you use? I don't know. Let me find out for you. I use Cremo Premium Barber Grade Hair Styling Sculpting Clay from Amazon. I will give you the link in the chat, Anish. This is strange. Not your question. It's just strange that I'm doing this. Lakeisha McMillan says, my case has been going since 2017. How much longer can they drag this out? I mean, it should be almost done. That's a long case. Are you in state court? Oh, local court dismissed on a technicality. We went to Supreme Court, and now they are back to local court with a new judge. Okay, so appeals make things take a lot longer. I can't tell you when that's going to be over because appeals work can go for years. My other channel says, Vince, your quality of life seems spot on. Thank you. That's very kind of you, my other channel. I agree. I think my life is exactly the way I want it. But I will say the path upwards through employment law can be taxing. Once you make it, once you have a firm and you have associates and you just do YouTube, things get pretty great. But, you know, until then, it's a lot of work and a lot of getting like spit on and stuff like that. YouTube user LC says, thank you, Vince, for answering my DOJ question. I asked my attorney on Wednesday, but she has not gotten back to me. Does involving the DOJ limit her benefit? Not really, because the DOJ is not. So the DOJ will represent you, but they don't always put your interest first. So having your attorney stay active and do things can still be very valuable. Tez Zinro says, I want change, but I have no faith in the company actually changing anything. So I'll take money to make them hurt a little. Sucks. I can't make change better for others. I mean, charging them money does force them to look at how they're doing things, right? It punishes them in a way that actually matters to them. Team Tahoe says, the court determined charges are wrongful termination with a pretext, discrimination, and retaliation in both Title 7 and ADA, and failure to accommodate. EEOC is done and defense has no evidence. No way for my silence. I applaud you. Well done. YouTube user Jim says, is it helpful to a case if the EEOC determines the company has a systemic issue associated with your case? And if so, to what extent? Yes. It does not formally make there be a presumption that the employer is guilty, but I think all regulators and potential judges will take notice of that finding, and they will think that perhaps, you know, where there's smoke, there's fire. Team Tahoe. Team Tahoe, I may not know the orders you're talking about. I don't know what context you're talking. It sounds like you're waiving HIPAA protections, which if I was I'll tell you, so if you're waiving HIPAA protections to make a point, and I was an arbitrator, I would say, okay, you can do that if you want. I don't care. It means nothing to me. And I'll tell you why. Like, somebody was like, I would like to know about Vince White's medical history. I would say, that's fine. I don't care. Like, I don't understand HIPAA. Like, I don't understand people wanting to hide their medical information. Like, it's their right. They can be private if they want. It's just not something that embarrasses me, so I don't care about it. And maybe that's just privilege because I don't have anything to hide in my medical history. I don't know. Girl 2011, happy to do it. NYC Damages says, my possible ex parte communication is NYC, so not a small city, and they didn't know pro se heard it. It was clearly meant for pro se not to hear. Is this a good reason to get them to recuse or disqualify from the case? And what's the difference, and how does a pro se go about that? So if you want this person off your case, if the person disparaged you to, opposing counsel, if you want them off your case, this certainly, if they're disparaging you and you can prove it, this could be enough to do that. That's an option. You can make a motion asking the judge to recuse themselves, and she or he can do so. You can also file ethical complaints. There is an ethical process in New York that you can go through to address judges' misdeeds. I find that ethical process to be somewhat unresponsive, although what I find to be most responsive in terms of moving the needle on whether a judge stays on a case or stays on the bench, in my personal experience, is a little bit of press. And here in New York, the New York Post will often be your best friend when you're looking to unseat a judge. I certainly have played that card, and I highly recommend it. So NYC damages, perhaps consider that. Diesel says, hey, Vince, I've watched all your videos on how to determine the value of a case. However, I feel the value of my case is being undervalued. Sorry to hear that. We have like 5 claims, including discrimination, retaliation, and admission of some failure to accommodate in writing, and many other things. Why would it ever be less than $300K? So I'm not saying it is less than $300K. I don't know anything about your case or how it's valued, or who's telling you it's below $300K. But I think the argument someone would make as to how a case could be worth less than $300K is as follows. You earned, we'll pick a hypothetical number, 50 grand. I don't know what you earned, right? You earn 50 grand, you're going to mitigate in less than 3 years with comparable employment, probably faster. So your economic damages are 150K or less. You have emotional damages, but Diesel, I don't know anything from your profile picture. You appear to be a Caucasian person. It's very small, so I'm not making any assumptions about anything else about you. For Caucasian male, you are statistically going to have lower emotional damages than almost any other group in the lower 48 states, except African American males. So your emotional damages verdict may be low unless you have very good documentation. Mental health professionals, physical symptoms of anxiety, things of that nature would be very helpful. So you have a retaliation claim. The punitives, they're not going to negotiate on the punitives. So you have to go to trial if you want to get the punitives. So why would you settle for less than $300K? Because we just described a case that was worth $250K with the chance of punitive damages, and you might not want to face trial. I'm not saying you should settle that. And the beauty of the situation is you're the decider, right? You have full control of whether you choose to settle your case or not, right? You can value it anything you want. People might not agree with you. Those people might be your attorney, might be the judge, might be the mediator, might be defense counsel. None of them have to agree with you. It doesn't change anything. You don't have to suddenly say, oh, well, you all don't agree with me, so I better take this settlement. That's not how it works. You're the decider to channel the evil George Bush Jr. I'm the decider. I'll never forget him saying that. What you have to understand is, you see, I'm the decider. He was such a gremlin. AR American says, Mr. White, hello, sir. If I already received 3 settlement funding loans recently, all totaling approximately $5K, does that mean I could potentially have a very good settlement? If you took out 3 settlement funding loans, I fear that you will have no settlement left at all. I don't know the terms of the loans that you took out, but often settlement funding loans have really aggressive predatory terms, and they can very rapidly eat through any settlement you might have. Often we decline to work on cases where clients are borrowing against their settlement, because ultimately the client will receive $0 on that settlement, and so they have no interest in the outcome of the case, and they won't do things like show up and testify or anything like that. Okay, what do we have here? Slater case says, my employer ignored my claim after my right to sue letter, and a week before decided to offer me a remote position in exchange for dropping my case. Is it a bad idea not to accept and file in federal court? Depends entirely on what you want. If you want the remote position and that makes you happy, then that's a great deal. If you don't, and you want to fight this out and you want to go for money, go to federal court. I think that's tremendous. Let's see. YouTube user 2Lamort says, I found a lawyer. OMG, I was seriously losing hope. He seems like a good guy, and the first thing he did was send a demand letter to the lawyer that ghosted me after I sent him a $600 retainer. I love that. I'm very happy about that. Wonderful. Devin says, congrats to Lamort. I hope you win your case to the fullest extent. I agree. Juana Washington says, whoa, chat jumped ahead. I lost. Juana Washington says, did I hear you say go to the police for my manager touching me at work? I won't get fired. Could this stop him from working near me? Is this wise? So check with local counsel. But in New York State, I would potentially have you get an order of protection, what's called a stay away order of protection, which means he can't be within a certain range of you, a certain distance of you. And, this could be reasonable. This man physically touched you. He groped you, right? So I think it's a pretty reasonable ask. You can get a judge, generally speaking, to grant that, I would think. And then you go to work and you're like, hey, I got to stay away order of protection from this guy. So I'm going to be here. He can't be here. And then he's excluded. And that's great. John Paul Jones says $13 for that little tin. How much money do you make a year? John Paul, it depends on what we win. It changes every year. That's the terror of employment law. I've had a negative year. I've had a year where we funded cases and spent hundreds and hundreds of thousands of dollars on cases, and nothing finished up that year, and we did not make money. So it's different every year. But I will say that is not a little tin. I mean, that $13 tin lasts me 6 to 9 months, I think. I mean, just a little dab will do you, buddy. You don't need too much. You're not trying to, you don't want a helmet head. Just a little bit of clay. Put it in when your hair's wet. Mr. D says, okay, I appreciate all the words of wisdom and advice. If you ever get to Hampton Beach and I happen to run into you, drinks on me. Sounds amazing. I don't know where Hampton Beach is, but count me in. YouTube user Tiffany says, does your firm increase retainer for trial compared to original retainer for EEOC process? Could a client expect the same amount for trial retention, more or less? What factors determine this amount? Tiffany, so if somebody's with us through the EEOC, generally speaking, our goal is to not charge anything additional for federal litigation. Sometimes it's not possible. If something went wrong in the case and the risks of the case have changed, we might not be able to do that. But generally speaking, the goal is if you're with us in the EEOC, we had the case longer, so we've had more time to work on it. We have more investment in the case. So the goal is no additional charge. If a case comes to us fresh to the EEOC, and then the identical case comes to us fresh, we've never worked on it, but it's coming for federal litigation, we charge a lot more for the federal litigation because we haven't been involved as early. There's a lot more risk. There's a lot more work. Federal litigation is much more taxing. Much higher likelihood we're going to have to fly a trial team out. Much more higher likelihood we're going to have to fire a large trial team out. Like I'm going to be putting up many people in some location for a trial for weeks on end, and that's very expensive. So yeah, if it's a case we have not touched previously, like if it did the EEOC without us and then it's going to federal litigation, we're more expensive. Diesel says, I have a disability discrimination claim with retaliation, as well as my psychological doctor writing declarations about my emotional claims, as well as the fact that I had to get on antidepressants. I'm really sorry, Diesel. That sucks. I'm not saying your case is worth less than $300K. You asked me a hypothetical as to how the case could be worth less than $300K, and I just spit one out in 2 seconds. That's all I'm saying. Devin says, I had an attorney willing to take my case, but she wants to settle it and doesn't want my evidence. Is this suspect? She asked how much I want for my case and said they take 40% and I get 60%. So I have no problem with 40%. I think that's very common in the industry now. That doesn't worry me. I do worry about an attorney not wanting to see your evidence. That's very strange to me. How would she know the strength of her claims? How would she know what you should be settling for? Has she done a damages calculation with you? Like, this seems a little suspect, Devin. Baby Cakes 8 says, I have a personal injury case and in discovery phase for about 6 months now. I hope you know that I'm not a personal injury attorney. We have been granted summary judgment. Want to know how much longer will it take before my case ends? Well, I'm not a personal injury attorney, but I would think your case would probably be over in 6 months. Depends wildly on what jurisdiction you're in, but just a guess. Oh, Lord. All right, Diesel. I just saw you work for Activision Blizzard. Let's stop. Let's take a pause here. So, in the interest of I have to now operate this like a true conflict check. You told me you're associated with a company that I am good friends with many ex-executives of and game designers of, none of whom are still there, but and I'm not reading any more things you're saying because I just want you need to tell me if you want to keep talking to me about this or not. No one who I'm friends with is still affiliated with Activision Blizzard. I'm not even really sure if Activision Blizzard still, I guess it still exists in a much diminished capacity. But if you're talking about events from like long ago, the great sexual harassment issues of Activision and Blizzard, things of that nature, I have firsthand knowledge of some of those events. So you may not want to talk to me about those events. Not like I witnessed anything, but like I advised people during those events. So be aware of that. If you want to keep talking to me, it doesn't make me in any way not want to help you, but I have an ethical duty to inform you of that. And I didn't expect you to throw out your employer and activate a conflict check. But even though we're doing a live stream, I must still comply with all attorney ethics, and I am not interested in any way in harming you or my license. So we'll be doing this until you tell me you want to stop talking about this, or such time as you tell me you want to go forward. All right, I'm going to wait for Diesel to respond. And I will not talk about Diesel until I see a response from Diesel. Ron Snow says the EEOC in California doesn't give out right to sue letters. Why is that? So that is not true exactly. Their claim is that they have a state agency do it. However, you are not required to engage in that state agency, as I understand it. You are able to go through the EEOC. They just don't want to. They're going to tell you, no, we have the state agency do that for us. And you're going to say, yeah, funny story. Not interested. This is your job. Do your job. And, is what it is. John Doe KCK says, Vince, when it comes to steak, if you had to choose, what would you pick? A New York strip, a tenderloin filet, or a ribeye? I avoid tenderloins and fillets like the Apocalypse. I just don't think they're good. I think they're mealy and soft, and they have bad mouthfeel. I am always going to be a ribeye guy. I actually buy cow rib cages, essentially, and have them cut in volume to 1-inch ribeyes because I serve so many ribeyes on the farm. So I literally have a butcher that I go to, and like I call ahead and I'm like, I need a rib cage. I need like a full cow of ribeyes, and he will graciously supply them for me in conveniently stacked packs that I can freeze and thaw as needed. Tez Zinro, I agree. If your hair can't deflect bullets, is your gel really doing its job? I agree completely. Yes. John Doe KCK is giving you great advice, Jon Snow. You are absolutely correct. Life's a beach. Can my medical records be used against me in a wrongful termination suit? Yes. Yeah. So your medical records are going to be a battleground for a couple different things, including your emotional damages. Slater case says, if I file a lawsuit in federal court while still employed, will my job be protected? What should I expect next? So Slater case, you got to check out all of our videos on retaliation. We have an entire playlist on it. That's going to give you a huge basis of knowledge about this. I definitely hit that up. Your Mom 69 says, what's diversity jurisdiction? It's the first week of Civ Pro. You go to law school, you take Civ Pro, that's your first week. That's what it is. Chris Ritchie says, nice microphone. Thank you, Chris Ritchie. It seems to be working much better. Many YouTube users like John Doe KCK help me to get this wonderful microphone and get this nice setup, because I am not well versed in technology. John Doe KCK, I am not promoting products from Amazon. I'm sorry. Someone asked me what hair gel I use, and I just provided a link. I'm not promoting the product. I'm sorry. I'm sorry. I'm on the run here. Just taking hits. Okay. Team Tahoe says, I have a major emotional physical damages and defendants want me to sign a blanket protective order for my silence and all details of my case. Settlement. And they want you to sign non-disclosure agreements and confidentiality. Okay. Yeah. So if you don't want to sign that, don't sign that. I misunderstood. I thought you were trying to waive HIPAA protections in the course of some kind of discovery kerfuffle. And I didn't understand. If you don't want to execute confidentiality agreements in your settlement, then don't. You don't have to agree to that. They might not settle with you, but you don't have to agree to it. Pre-Citrus says, hi, Vince. Thank you so much for this channel. My pleasure. Can you please elaborate on using the New York Post to unseat a judge? I'm a pro se complainant. While I knew I'd be at a disadvantage working pro se, never managed the EEOC would outright lie when applying the law to the facts of my case. How can I legally publicize and unseat my investigator and or the director of the local office? So here's what we did. We have a pretty good relationship with the New York Post. We called up somebody at the New York Post and we said, hey, this judge did a bad thing. And this judge is affiliated with people you hate at your newspaper. Excuse me. And the judge is related to a assistant district attorney who also did bad things. And the New York Post got really excited and did a lot of stories about it. And then the state of New York started opening an investigation into that judge. And before that judge could be further investigated, that judge retired. I should say re-retired, but ended her time on the bench, essentially. The only difficult thing in that for you is probably getting the attention of someone at the New York Post. But let's be honest, it's New York Post. If you have the right political agenda, if you what you're doing matches their political agenda, they'll probably listen. AR American says, thank you for your response regarding the loan question. Mr. White, my lawyer did tell me he had worked with this defense counsel in the past and gives good value. Usually, that's great. I'm glad to hear it. John Doe, I'll tell you, I've sued every company in the country. If I did not do business with companies just because I sued them, I wouldn't have electricity. I would still have water. I wouldn't be able to fly on major airlines. I couldn't go to chain restaurants. I'd be very limited in my life. I've got a shop where I can. Anish wanted to know what was in my hair. I'm sorry. Redman says, hard evidence of perjury, defamation within the position statement. EEOC first said it was a constructive termination, but ruled dismissal after I turned it down. After I turned down an offer that didn't meet your salary. First said it was constructive termination, but ruled dismissal. Well, the EEOC didn't dismiss your case. They just gave you a right to sue letter, right? Right, Redman? I mean, it's not a dismissal. They're letting you go on to federal court. That right to sue letter gives you 90 days to get filed in federal court. Juana Washington says, I live in Arkansas, which is a one-party recording state. The head of my work is meeting with me next week. Should I record it without telling them? I did ask them to respond via email, but they insist. I'm not going to tell you to record or not record, but I'm going to tell you, if you were my sister, I'd stick a recorder on you and then not tell you about it. Lisa B. Lifestyle says, currently, I have a sexual harassment and retaliation claim against employer. They inflated a write-up and lied in an administrative hearing. Have you ever seen anyone pursue perjury? Is a separate civil claim. I have seen people pursue perjury. It is a separate civil claim. Diesel, no, I'm not giving them advice now. I am still friendly with executives from Blizzard, but they have moved on to different companies and they have not been involved with Blizzard in half a decade. And they did not move on from Blizzard because of any involvement with any horrible systemic sexual harassment issues, alleged or confirmed. Also, don't work at Blizzard in 2024. That's a bad place to work, which I think you've already found out. Yo Cannon says, is 7 figures possible in mediation? Yes. If it's against a large, well-known corporation, yes. I have a racial discrimination case with retaliation. Yes, it is possible. Dorzana DeFalco, I'm in California. Dorzana DeFalco, the YouTube user, says, I'm in California, and if I am harassed by a private contractor of the company, which cost me my job, is it true that the company is also liable? They knew of the harassment and did nothing. So you're, just to confirm, if you're working for the company, you're being sexually harassed by someone who's also working for the company as either a independent contractor or employee, that company is going to be liable for that. Yes. Potentially liable for that, I should say. Baby Cakes 8 says, thank you for the response. Would you please explain long-term suffering as far as in how that works? I know my attorney asked for our taxes, and that's something that he's trying to pursue. Long-term suffering. So emotional damages, and I'm not a mental health professional, obviously, but as I understand it, they can be both acute and long-term, right? You can suffer emotional damages that stay with you for the rest of your life. Classic example of this can be certain forms of PTSD, which can often be viewed as incurable. Treatable, but incurable. You will deal with PTSD for the rest of your existence if you are a human being. Is that what you mean by long-term suffering? I mean, you can also have like short-term, not trying to be funny, it's just what leaps to mind. People have short-term issues with IBS, right? Like they have an anxiety condition that springs from what they're experiencing in the workplace, and that triggers additional consequences. And they, for a period of time, 6 months or a year, whatever it is, suffer from irritable bowel syndrome or lack of sleep, insomnia, things of that nature, high blood pressure, elevated heart rate. These are all things that can be short-term or long-term. So if that's what you're asking, like that might be what your attorney is talking about. Team Ribeye is the winning team. I agree completely. Ribeyes are the most delicious of all steaks. John Doe KCK, I would like to know your ribeye recipe. How do you approach it? I like personally to salt my ribeyes liberally, put them in the fridge for about a week so they can do the poor man's aging, dry them out, really, really get them dry. Then pat dry when you take them out, let them come to room temperature, hit them on a 450-degree skillet, or if you're feeling fancy, throw them in an 850-degree pizza oven. And about, depending on thickness, let's assume a 1-inch thickness, 2.5 minutes on a side, pull it out, medium rare. That's my ribeye playbook. Your mom 69 says, did you say Civ Pro? What's that? So civil procedure is a law school course that deals with, for almost the entire first third of the course, deals with things like diversity jurisdiction. And I guess I was being flippant. So you asked me, your mom 69, what is diversity jurisdiction? I'll give you a quick answer. It's a means to get things into federal court if there's enough touches in different states in the country that you can make a good reason for it being in federal court. You don't generally need diversity jurisdiction in most employment cases. Generally, that's going to be a bar that's met. Now, when I say what is diversity jurisdiction, and I say it's the first week of Civ Pro, what I mean is it's something taught in law school. It's a very complex concept. It both is and it isn't. Like, the core of it is very simple. The long form function of it is not. So what I was being kind of flippant about is that it's not something that I'm going to be able to teach you in a live stream on YouTube. Not because I don't want to, but because this is not a good venue for doing that. And also, it's not something to be taught in a vacuum. Like, diversity jurisdiction requires knowledge about a variety of other topics in the legal realm that you need to pull from as you establish your full understanding of diversity jurisdiction. I just noticed we had 65 concurrent people. That's amazing. That's the most I think we've ever had in a live stream. Very, very cool. Sean S says, would you allow a client to voice their opinion on settlement amounts, taking into account that they've mitigated the amount seriously? I.e., no emotions involved, just numbers on paper? Always. Yeah, always. If I catch an attorney who is not letting the client speak about the valuation of their case in my firm, that is a serious issue. And that is an issue we've had because employment attorneys are obsessed with the idea that they know best. And you have to just be like, yeah, so I don't even know that you're wrong, employment attorney who works for me. I don't know that you're wrong, but I do know you're going about it the wrong way, right? Like, the issue isn't that your valuation of the case is flawed. In reading your valuation, I think I agree with your valuation. The issue is that you're telling the client the valuation and then telling them to be quiet about it. That's not ever going to be okay. You need to hear the client. The client's the boss. The client's the decider. Yes. Scott Niebarger says, is it reasonable to suggest it should be possible to earn a Juris Doctorate with just an associate's degree or an AA? I think so. I don't think there's anything taught in a 4-year collegiate program that is fundamentally valuable to the practice of law, right? Like, I think that proposal is very reasonable. Life's the Beach says, how far back or forward my how far back or forward will my former employer subpoena my medical records? So probably up to the current moment, and going back, I mean, they're going to try for as long as they can, but probably get limited to 5 years. Your Mom 69 says, what is a tolling statute? A tolling statute is, well, a tolling agreement is an agreement between parties to not enforce a statute of limitations. I assume that might be what you mean. Your Mom 69 says, do you take tolled cases? I do if they're healthy and I like them. Chris Ritchie says, Diesel says, excuse me, do you take cases outside of New York? Yes, we take cases in all 50 states. Why do you need to fly people out? You said that earlier. Because I take cases in all 50 states. So we take cases in the EEOC and in federal court in all 50 states. We hire local counsel when we're in federal court, and we fly out a trial team. It is expensive to hire us to do that for the obvious reason that your local firms don't have to fly attorneys around the country, and they don't have to put people up in hotel rooms. So clearly, if you're hiring us, it's because either you don't like your local options or you have the money and you want our firm for some specific reason. Chris Ritchie says, what happens when you sue your boss once they cross the legal toxic line and not your employer? I mean, you sue just the boss, but not the employer. I've never done that. I would not agree to do that. That would sound like a low value claim to me. So I am not well versed in answering your question because I have never done it. I can't tell you how it went because I have never tried that. But you asked another question. Did you sue UPS? Yes, I did many, many times. YouTube user Ron Snow says, if the investigation uncovers other crimes committed by the company or government officials during your investigation, are they obligated to report them to the proper officials? Depends on what the crimes are, I suspect. If the federal government uncovers like misappropriation of federal funds, if I recall correctly, they have an affirmative duty to report that, but don't quote me on that. It's not my field of expertise. Aquarius 182 says, can I sue my employer for failing to offer reasonable accommodation due to a disability for disability discrimination? Yes, that is a claim. John Doe KCK says LMAO. New York Post has orange stains. Oh, yeah, this is funny. So, John Doe KCK says, are you allowed to visit Madison Square Garden? So I have actually sued Madison Square Garden repeatedly. And I recently went to a Knicks game with a friend of mine. And I was very agitated because Madison Square Garden will identify with facial recognition attorneys who have sued them previously and will have those attorneys removed by security. I was offended that they did not do that to me. It is possible that either I'm not a big enough fish in that front, or that they don't do that to employment attorneys who bring employment cases because of prior case law on the issue of employment attorneys being banned from certain venues, like, say, Soul Cycle, and suing for retaliation, which did happen. And I've certainly been banned from restaurants and other venues because I brought cases against them. And then once almost had a fist fight in a meatball shop that I did not know I had sued. Actually, I hadn't sued them, for the record. I had not sued them. I had been hired when I was a young attorney to handle a deposition for an out-of-town firm against a like a franchise owner of a meatball shop. And I guess I got a little bit wild. That deposition got a little bit lit, and that gentleman remembered me for a couple of years. And then I walked into his meatball shop, and it was on. It was on. Excuse me. Devin says, would it be immature to reject a settlement due to the employer and HR letting you be tormented for over a year and never caring to settle issues then? I don't like not being able to speak about what I've been through due to an NDA. I think it's called where it protects the company's image to me. So it's not immature, right? The main question is what you want. And if you want to feel vindicated, you might need to go to trial. Like, if you're telling me the settlement amount is not going to make you feel vindicated, it's not going to make you feel that you've been made whole, then you wouldn't take the settlement amount, right? I don't think it's immature. It's not probably what I would choose, but I'm also not in your shoes, right? My baby girl P says, what's your cat's name? I learned a lot from the channel. I'm really glad you learned a lot from the channel. My cat's name was Aston. Unfortunately, she passed from liver disease a couple of months ago, back in, I think, January. She was a wonderful cat. I miss her very much. Diesel says, I guess the main thing I'm concerned about is that I feel that the main amount being offered, excuse me, I must have had some carbonation. I feel the amount being offered is just too low. I would have expected 500 to 700K because I think we could win punitives. So yeah, if you want punitives, go for punitives. You're just going to have to go to trial, right? Like that. What you're saying is you want to take a swing at the highly speculative world of punitive damages vis-a-vis a retaliation claim. And that is not an unreasonable thing to do. However, it does mean that most defense attorneys are going to force you to embrace the risk of trial to do that. And that's well within your rights to choose. I don't think there's anything crazy about that. I should not use the term crazy, but there's nothing foolish about that. Diesel goes on. I don't think maybe 400 to 500K is more realistic, but given the reputation of the company, I think they would be significant. Yeah, so I will say one thing about Blizzard is they're a little bit like the MTA. If you're like, MTA, I'm going to ruin your reputation, the MTA is going to respond, we are already statistically voted the most hated organization in New York. We're more hated than the NYPD, and the NYPD literally kills people sometimes, right? So, there's not a lot that a case can do to move the needle on the MTA. And at this point, I mean, Activision Blizzard, That's the worst neighborhood in gaming, in game design, right? I mean, I don't know how they produced. What's that? They had a new Diablo that was pretty good. People said. I mean, I'm not going back, but people tell me it's good. So who knows? James Leif Anderson, what to do when your Americans with Disabilities Act rights are violated and the employer does nothing? File a claim. The EEOC complaint made? Good. 6 months still in need of accommodation. Employer won't respond to multiple ADA requests. Can I do anything else? You could pull your right to sue letter from the EEOC and file in federal court. That's probably the next step. It is 6:30. We are going to go for 30 more minutes. 30 more minutes. We have 30 more minutes on the live stream. 61 people live, 25 likes. There's 61 people in that chat. I have questions why I only have 25 likes. Questions, people. Questions. These are the questions that rule our lives. Chris Ritchie says, what happens when you record when told not to, especially when you are in arbitration with your employer and not a court forum status? I generally would not recommend recording in court or in arbitration. Outside of court or arbitration, there's not a huge amount of consequences for recording when you're told not to, although I can't tell you to do illegal things. NYC damages, even employment discrimination cases will become political. NYC damages, yeah, employment discrimination cases are inherently political. If I go back to my hometown, people call me a race traitor. These cases are political, and it is what it is. AR American says the interest rates for the loans are actually really high, around 50%, 40%. I'm sorry, that is incredibly high. AR American, I am sorry to hear that. John Doe KCK says, Vince, with all the Californians that seek your help, I am seriously tempted to attend a guaranteed seating of the California bar exam, sort of law school. We need more lawyers. I would be thrilled if you did that. Hey, somebody just gave me $4.99. My gosh, it's ticking down. How do I? Oh, Chipper Boy says, do you offer limited scope representation? What are your thoughts on it if you're familiar with it? We do not. We do not offer limited scope. I'm sorry. I don't think there's anything wrong with it. I just think our firm's resources are better spent investing heavily in cases that we can work on in the long term to reduce risk and add value. We like to spend heavily on our caseload. We like to spend both time, attorney time, and money on those cases, improving their value. So I don't think for us that limited scope representation is a good option. However, if you are pro se and you want limited scope assistance, I think it can be invaluable, and you can find really good attorneys who will do that. The issue is when finding those attorneys is that you will find no end of attorneys who will take your money. The important thing, and I'm sure Jipper Boy, you don't have to give me money. You don't have to give me money. I'm going to answer all the questions. You don't have to give me money. Somebody just gave me $10. The issue is you just got to find somebody who's going to really do a good job for you. That's the important thing. All right. What do we have? Oh, one in Washington. That's very kind of you to send me $10. You definitely don't have to do that. I'm thrilled to help you. It is the least I can do. I'm a white guy making money off discrimination. Nobody's ever going to sexually harass me. Nobody's ever going to discriminate against me. Maybe when I get older someday, but probably not. Right. So if I'm going to make money off discrimination, I should be helping people. I really appreciate it, but no need to send me money. It's very kind of you, though, and thank you so much. Scott Niebarger says he is Googling something for me. Thank you, Scott. I don't know what you're Googling, but thank you. Excuse me. Lakeisha McMillan says they paid for mediation and said my case wasn't worth it. First offer $70K. We ended with $325K offer, but they want me to walk away from my pension. They came back a week later and offered $750K. Should I go to trial? Most of the bad actors are gone, and I don't necessarily want to quit my job, especially considering how much money I will leave behind with them cashing out my pension. I mean, so you got to calculate the value of that pension over time. I mean, that's going to be, I would sit down, honestly, your attorney, I don't know what stage your case is in, but your attorney may have already hired an economic expert on your case. And if they have, one of the things you can talk about that expert with is like, hey, what's the valuation of my pension over time? What's the opportunity cost of me getting $750K now? Excuse me. And like, do the math for yourself, strategize for your life, decide what you want. But listen, if they're offering you $750K and you return to work and you keep the pension, sounds positive. I don't know the case, but I mean, that sounds like a good start. If that's not the case, they're trying to get you to give up the pension and leave the job. Hard to give up a pension, especially if your pension's indexed for inflation. That's a really big deal, right? So I can't really answer your question because I don't know the situation, but certainly it sounds like you're on the right path. I'm very happy for you and for your attorney. Aquarius 182 says, if my medical professionals state that I need 4 months off on FMLA due to bullying and hostile work environment from a primary supervisor and an internal transfer upon my return, and they approve a few weeks and deny the internal transfer, can I pursue legal action against them? You can. You absolutely can. Yeah, there's no reason you couldn't. I don't know enough about the case to tell you if that's a winner or a loser, but I can tell you that you certainly have the ability to pursue that claim. Your mom 69, I have definitely taken a told case for a plaintiff. Yes. Devin, thank you for telling people to like the stream. That is very helpful. Liking the stream helps us with the algorithm a great deal. Dwayne Harper says, thank you for your helpful videos. My case settled a month ago. I'm so glad to hear that. I hope it's a good settlement. My advice is please be realistic about your damages if you were not employed there long. Dwayne, I applaud you. Well done. My channel is jumping ahead on me. Oh, thank you, Dwayne. Dwayne says, congrats on 100K. Thank you very much. I think we're at over 110K now. John Doe KCK says, I'm a reverse sear on a barrel smoker guy. Marinate for 4 hours. You're marinating ribeye? Sir. Ribeye does not need your marinade. Whatever you enjoy is good for you. Wrap in foil, put in a smoker until 100 degrees, then unwrap and sear over Kingsford briquettes and a mix of apple and pecan wood. I mean, hey, I'm not going to knock it until I try it. I am uncomfortable with the marinade. Everything else you said sounds amazing. Carol Mosher says, how do you overcome the bad leader, bad manager defense to employment discrimination? My company said my manager is not racist. They are just a bad manager. You need to, so Carol, I'm not trying to be funny when I say this. You'll need to present evidence that supports the idea, evidence that could help people to believe the manager was engaged in racism instead of incompetence, which is the most general answer and an unsatisfying answer, but is the only answer I can provide you because I don't know your case and I don't know the evidence at your disposal. Your mom 69. Yes, I've answered this a couple of times. We have taken told cases. Can you talk about it for the chat? But more so about a neutral explanation of it from both your side and the defense's side, pretty please. So often told cases are cases where the defense and the plaintiff side are working on a settlement, and they've been working on a settlement very hard. And they've been working on that settlement very hard for some period of time, and they run up against a statute of limitations. And the statute of limitations makes it impossible for them to keep working on their settlement, so they engage in a tolling agreement where they say, hey, we both agree not to apply that statute of limitations. You can still bring your case free from any defenses, any statute of limitations defenses, but we're going to use this extra time to continue working on settlement. Often that will happen in cases where a pro se litigant has felt less than confident settling her or his case because they're not represented. And so they're like, listen, we're right up against the statute of limitations. We've been negotiating in good faith. We've gotten really far, but I do think I need an attorney for this. I'm not going to be able to get this case filed with an attorney by the statute of limitations, but I'm also not going to take the deal. If you want to keep these negotiations going, I need a tolling agreement so I can go hire an attorney and they can finish the negotiations for me. I see no issue with that. We've certainly taken those cases, although often those cases are presented very poorly. Like the tolling agreements are often not explained in ways that is entirely useful. So you do have to be careful how you explain what went on. But yeah, we certainly do take those cases. AR American says, is it true filing in state court gives better chances of winning instead of federal? If so, why? Depends on your jurisdiction, AR American. So it's entirely up to your jury pool, right? And sometimes the judge. Like sometimes you might feel that certain courts, certain judges, certain court systems might have certain bias. So you might not want to expose yourself to that court system. But generally speaking, the most meaningful characteristic of where you file is the jury pool that you're pulling for that given court, right? So if I'm in the Bronx, New York, I might file in state court because I might get that sweet, sweet jury pulled entirely from the Bronx, which is generally going to be incredibly employee friendly, right? And is also generally going to have some kind of demographic statistical understanding of what it feels like to experience discrimination of various sorts, right? The population of the Bronx, they haven't all experienced discrimination, but if you're going to look at a group of people, I think statistically, the chance that a person who lives in the Bronx has experienced discrimination in the workplace is exponentially higher than a person who lives in, I don't know, Montana, right? Maybe. I don't know. That's just my guess. So you look at your jury pool, and oftentimes in federal court, there's an advantage in federal court in that you can bring all the claims for the federal claims, all the state claims, and all the local claims. That's an advantage you have to weigh as well, but it is ultimately the jury pool that you're looking at. Baby Cakes, I may have missed something you said because you're talking about black mold, and I don't know. Oh, I'm not a doctor. I don't know anything about black mold or the condition or what it does to you. I'm sorry. I don't have any knowledge. Juana Washington says, does your firm accept contingency outside of New York? Can I get a consultation? If so, you can contact our intake people. I can't tell you what they're going to offer you. I can tell you they will generally be more expensive than firms that are local to you because our firm has to fly attorneys around the country. Anish says, can my attorney drop me as a client for any reason? Well, first off, depends on what it says in your retainer agreement. But generally speaking, there's no requirement usually to maintain representation. But if they do drop you, they're not going to have a lien, and they may have some ethical issues if they harm your case and how they drop you. What do we have? Slater case says, if the same manager who retaliated against me 3 years ago is subject to my current federal court filing, and I previously reported this to HR without any action taken, can I include this in my present claim? Sure. That's valuable background information. John Doe KCK, 1 week of being cigarette free, my lawyer took my SIG money, LMAO. Did your lawyer take your money? Or did your lawyer work hard not to take your money? MSG is too afraid of you. I hope so. I don't think that's the case. Juana Washington, thank you very much. She said, I'm so sorry about your fur baby. Thank you very much, baby girl. Thank you very much, Devin. Very kind of you all. Sport Fanatic, welcome back, Sport Fanatic. It's been a while. The vice president gave a ruling regarding my disciplinary hearing. Now that I've proven that wrong, HR is stating that the vice president had no authority to make that claim. Is this pretext? I don't know if it's pretext. It's certainly something, but I don't know if it's pretext. Nicodemus Hartzog, to submit questions, you just type them in the chat. I go straight down the chat, and I try to get to every single question if I can. This chat's going to go for 16 more minutes, so I can't guarantee I'll get to every question, but I'm going to do my best. We're gonna pick up the pace and try to answer as many questions as we can. Your mom 69 says we've already answered that question. Tiffany says, when assigned a team within your firm for the EEOC process, does the same team carry the case to resolve resolution, or would the client have different team if they went to trial? Tiffany, I add and remove attorneys from teams as required. So cases that go different directions might have additional document review attorneys added to it. They might have additional contractors added to it. Cases that go to trial may have additional trial team members added to the case. Generally speaking, the core of the team remains unless an attorney moves on. Listen, attorneys do occasionally move on, like attorneys come and go. Associates are not stuck. Like they can make lateral moves in their life and you know, jump to other firms, stuff like that. Oh, Nicodemus, there's no my bad. There's no my bad or anything here. I'm just telling you that if you just throw your question in the chat and I'll get you an answer. Thank you so much, my other channel, for encouraging people to hit the like button. That helps our firm with the algorithm. Juana Washington says HR is watching. They don't issue likes. They just watch from the bushes. That's absolutely correct. That is absolutely correct. Oh, all right. I was able to like Jipper Boys. Oh, I can like. Guys, I can put little hearts when people give me money. Don't give me money, but I can actually, it's just fun that I can give hearts. John Doe KCK says New Diablo is actually trash. Baldur's Gate 3 is way overshadowed it. I have been entirely in a Helldivers 2 world for the past 3 months. I am a lover of Helldivers 2. I'm also a lover of Team Fortress Tactics out of Riot Games. Those are what I'm playing these days. Diesel says, out of curiosity, how would you evaluate a case like this? The main problem is I see that some of the stuff from the past does not have a written record. My manager had asked me about my disability back in 2022. Then he has retaliated and just constantly asked me to do stuff over and over again in my work. Then asked me for accommodation because my doctor thought it could help me. And then I was delayed for many months and then put me on a PIP 3 days after waiting like 4 months for the accommodation request. Now they just ignore me ever since counsel got involved. That sounds like a good and valuable case, Diesel. That is how I would evaluate that. I don't know enough to give you evaluation, but that sounds like a good and valuable case. Devin says, are there any laws against employers lying on their position statements? Well, it's not a sworn statement, so there might be in certain state jurisdictions. Remember, there's position statements in state agencies as well, but generally the consequences for inaccurate information on the employer's side in an EEOC position statement are almost non-existent. The defamation laws do still apply. Yeah, if you have something that meets the elements of a defamation claim, then that defamation claim would be potentially viable. Excuse me. Devin goes on to say, there's emails that show me reporting sexual assault, retaliation, needing accommodations for my disability. Let me go on here. That might be the last thing Devin said. Okay. Let's see. Next question. John Doe KCK says, wait, so you were raised in Whitey McWhiteville? Yes, until I was, I don't know, like freshman in high school. So I lived in a town that was very Caucasian until I was about a freshman in high school. And then my town cut a deal with the state to move projects from New York City into my town. And the demographics of my town changed very, very rapidly. And in all the wisdom of local and state government, no one ever thought about having some kind of orientation for the people coming from New York City or some kind of cultural awareness campaign for the people living in my somewhat hick town. So there was a lot of tension that erupted from the poor management of that combination of two populations with vastly different life experience. Would be the best way to put it, perhaps. That's true, John Paul Jones. Age discrimination can affect everyone, but I don't work for anyone else technically, as I am a partner in this firm. So I guess they could try to vote me out, but I can't imagine where they'd get their cases from. I'm kidding. Nicodemus Hartzog says, when do you tell your client to sit back on a disability discrimination case? You mean like sit back as in not take a settlement, or sit back how? Like what kind of sit back are we talking about, Nicodemus? Lisa Loves Soul Spirits 55 says, I got pushed me out of my call center jobs due to not liking their music. They didn't say that. They just manipulated another reason. Not true. Sounds like a pretext. Sounds like they made up a pretext to push you out. Musical taste is not a protected class. Unfortunately, although I could see there being some cultural issues, national origin, race issues, potentially tied to music. I could also, listen, there could be some orientation issues. There's some associations between music and certain protected classes. So it's not a lost cause. Just generally music preference is not a protected class. Who is giving me money? Why? Why are you giving me money? Vince, this is from, oh, what's happening? What's happening? How do I like it? Okay. No, I deleted the message. No. Wait, what happened? Sport Fanatic, I'm so sorry. I deleted your message. What happened? How do I get it back? Oh no. Sport Fanatic, can you type that message again? It was a really sweet message and I wanted to read it on the channel. I'm so sorry. I did not mean to do that. I don't know. I don't know how I did that. Don't give me money. Sport Fanatic, I just want the message. Nicodemus Hartzog. So if you have a good claim, and you don't want the settlements they're offering, I would say, great, let's go to trial. Why not? Sport Fanatic, I'm so sorry. I did not mean to delete your message. I literally clicked on your message to view it, and like it told me I deleted your message. I don't know what happened. Okay. All right. Cut off for questions. No additional questions. I got to get through these questions. I only have 8 minutes left to answer questions. So I got to run through these quick. Nicodemus Hartzog says, hey, Vince, is a job offer letter a contract if it comes with an NDA? Generally, job offer letters do not construe to be contracts, but it is possible. It's possible for a job offer letter to be construed as a contract by certain judges in certain situations and in certain jurisdictions. Lakeisha McMillan says, I'm in Michigan. They don't want me to collect my pension. They want to cut me a check and have me leave. I had to ask my attorney to hire an economic analyst because girl math. I don't do numbers, LOL. Listen, math is for everyone. My very basic calculations show their offer isn't worth it. I mean, I think there's a really good chance their offer is not going to be worth it, but I think it's a great idea to have the economic expert take a look. My company, Carol Mosier says, my company fired my racist white supervisor and placed him with a black supervisor. Does that hurt my past claim of discrimination by my white manager? No, because what happened. So everything that happened under that old manager already happened. That is the basis of your claim. Them putting an African-American person in doesn't mean that your claim is any less real or that it changed. Dakota Denali says, hey, Mr. White, for your New York residents, I know the deadline is passed, but has your firm or other firms taken workplace sexual assault cases under the Adult Survivors Act? I have actually not had any cases under the Adult Survivors Act. I know that Jeff Brown over at Leeds Brown in Long Island, I think he's taken a bunch of cases under the Adult Survivors Act. I think he's been very active in that field. He might be a better person to talk to about that realm of case. All right, I'm losing time. I gotta stop being social and just answer questions. Psalm L003 says, what if my team of 7 has never once responded or stuck up for me when discrimination has occurred, and I don't believe they will corroborate my claims other than the one black person on my team? That's more common than you think. It doesn't mean the case is in any way defunct. Your testimony, your evidence, and the testimony of your one coworker can easily be enough to get your case to move forward. Yes, John Doe, that is a good point about jury pool. Team Tahoe says, I initiated a doctor prescription, ADA reasonable accommodation. Employer refused to participate in interactive process, notified our co-counsel, provided the doctor note, inquired about job protection, then I was laid off. That certainly sounds like a claim to me. Lisa Love Soul Spirit 55 says, in Florida, at will employment. I got a few weeks unemployment to not get hired in any one of them Deerfield, Florida. So now I'm limited on jobs, so I get discrimination. Don't fully understand. Eliza B. Lifestyle, can you give a ballpark valuation of a perjury defamation claim against a state municipality? No. You have to prove damages. Damages are different in every case. There's no way for me to tell you. Mimi says, signed retainer today for the Bell Law Group. Glad and nervous all at the same time. I'm going to try to have John Bell of the Bell Law Group on the channel. I'm really glad to hear they were able to help you out. And I think they're good at what they do. And I've been trying to send them a lot of the folks that we can't quite help or who can't afford our firm for federal employee stuff. They're really great. Yes, Chris Ritchie, Boeing does appear to have blood on their hands. Sport Fanatic says, no problem. It's stated that we as the community appreciate you, what you do, and the ribeyes only need salt, pepper, and high heat. So, Sport Fanatic, thank you for the message again, and thank you for the $5. It's very kind of you. Question for you on pepper in a high heat environment. This is a much debated topic. A lot of people will tell me that pepper on a ribeye in a high heat will become accurate because it burns. Do you have feelings on this? Do you have thoughts? Tell me. Fill me in. Global Family says, I'm not happy with the settlement negotiations. Will filing the suit spook the current employer? Certainly could. Definitely an option. NYC Damages says, we have an employment attorney who says, don't give me money. LOL. NYC Damages, let me win my money. That's my job. I shouldn't get paid unless I win something for you, right? That's the whole game. That's what I signed up for. I can't just be getting free money. Didn't help anyone. All right, what do we got? Is that the end? Okay, I'm gonna miss a few here. We got 3 minutes left. Team Tahoe is finishing up. Oh, very kind of you, Nicodemus. Nicodemus says, God bless you, Vince. Pray you love past 100 years. Thank you so much. That's so kind of you for saying that. Thank you very much. Ooh, Papa Smurf, you're telling me use peppercorns uncracked and heat and butter? I agree with the heat and butter. So, Papa Smurf, I will say this. I think people lie about the smoke point on butter. I think if you use full fat butter churned at home, the smoke point is substantially higher than butter purchased in the market. And it can easily survive a 450-degree pan without any negative issues. Any negative issues. All right, everybody. Lisa B. Lifestyle, it's very kind of you to say that. I hope you're all well. Oh, thank you, Global Family. Very kind of you. So kind of you. Don't give me money, but thank you very much. And, oh, okay. Nika Marie, I'm so sorry. I don't deal with CPS cases. I'm only an employment attorney. I don't have the knowledge to advise you on that. Everyone, have a great weekend. Have a great holiday. Oh, last question. Heather's opinion. I have 2 cases that were sent to arbitration for federal court. The American Arbitration Association, which in the interest of full disclosure, I arbitrate through as an arbitrator for the AAA, is trying to dismiss one of them because the cases are similar. Can they do that when the judge did not miss my cases? I mean, when the case goes to arbitration, it becomes under the purview of the arbitrator. So if there's a legal reason why the arbitrator can probably dismiss it, then they can. They can, but it would have to be appropriate. And if it's not appropriate, you can go to a judge and you can appeal them. All right, everybody, take care. John Doe KCK, I would send you an additional temperature probe from Amazon, but I don't want to do that. So I'm totally messing around. I'm sorry. There's very good vendors. I'm sure we'll find a very good vendor with a good temperature probe. All right. Take care, everyone. Have a great holiday weekend. I will be going whale watching. I'm very excited. Take care.